All right, ladies and gentlemen, welcome to the show. It is Ask the Experts here on Talk Radio 1190. Do the show every Saturday, of course, 10 to 12. And what do we do? Well, we interview local prominent professionals here in the Dallas-Fort Worth area on their area of expertise. I'm the host of the show. Joining me on today's show is attorney David Pritchard. Great to have him back. It's been a while since we talked to him, so I'm excited for everything we have lined up. Of course, you can find him online at dlplegal.com. That's dlplegal.com. And Mr. Pritchard, what tends to be the best number if people want to reach out to you?
The main office number is the best number. That is 817-285-8017, and that's directly into the office.
Perfect. And, we got so much to cover today's show, and, we'll roll right into things. I know we want to get going. And I think what we really want to talk about today is regarding the first meeting when they are setting up things with you and regarding that and their finances. So break that down for us, and I guess to play into that, give us a little overview about your legal team.
All right. We're a small boutique office. It's two attorneys. We practice consumer bankruptcy, and we've been doing it for a long time. I think my 40th reunion is coming up from law school. Chris Barber, who works for me, has been doing it more than 25 years. We help people who have financial problems. That's what we do, and that's what we've been doing.
So if somebody comes in and they want to set up a meeting with you and kind of go over things, what should they expect in that first meeting?
Well, the first thing is that we're going to talk about what brings them there. And generally, I find there's three things. Number one, a lot of times people have been sued or they've got a notice from their mortgage company, and that brings them in the office. The second that brings them in the office, or what should bring them in the office, is if you're going backwards on a monthly basis. Let's say that you're paying the electric bill by charging it on the MasterCard, and then you're paying the MasterCard by advancing on the Visa card. Well, that's a sign that you've got serious financial issues, and we ought to talk about it. Then the third is more of a generic, and that's a different level for everybody. But it's your stress level. Are you worried about your finances all the time? Are you arguing with your spouse about it? And that's a different person. I tell people regularly that if we get a bill at the house, I might set it aside and we'll pay it when we get around to it. My wife, she's going to grab that bill and write a check right away because she doesn't want to worry about bills. People are just different in their stress levels. But if you're getting notices, if you're getting sued, or if you're just stressed out all the time, you should come in, and at our office it's a free consultation, and we can help you determine whether bankruptcy is right, and if so, which way to go.
And if they are in that situation and they do need to file about it, how do they know that they should file for it?
Well, it's really the problem they have, they can't put a plan together. If you know you got credit card debt and you're putting so much aside out of your paycheck to pay it each month and the debt's going down, then that makes sense that you've got a plan. But if you don't have a plan and you don't understand and you're feeling that stress, come talk to somebody and let me help you develop a plan.
And I know that, you either have an option between a Chapter 7 or a Chapter 13. How should they know which one to choose, or should they file for that bankruptcy in general? How's that work?
Well, that's going to be something that you should learn at the appointment, and something we'll talk about.
Okay.
Chapter 7 bankruptcy is we're going to wipe out, or the bankruptcy term is discharge your unsecured debt. So your medical bills, your credit cards, your debts to somebody that you agreed on a personal loan. Those are simply going to get wiped out. But a Chapter 7 isn't going to help you with your mortgage, with your car, if you've got tax issues. If you've got those issues, you're behind on your mortgage, you're behind on your car payment, you've got IRS issues, you're going to be looking at a Chapter 13. Now, there's one other thing that's individual in each case, and is that the court system, the legislature has said, if you make so much money, you have to file a Chapter 7. A Chapter 13. And a Chapter 13 is a repayment of a portion of your debt. So we see people that come in and they have $3,000 extra at the end of the month, but they still can't solve the big problem. Well, they're going to be in a Chapter 13. But we'll talk about that, and it's in each case we'll analyze it and be able to tell you what we think is the best way for you to go.
Now, and I know a main question that probably people tend to ask you is if they're looking at filing for bankruptcy or they're in a scenario like this, they're probably wondering, well, what exactly would happen to my house if this does arise, I guess you could say.
All right. In 90% of the bankruptcies, the goal is to keep the house. There are some people that have just recognized that for whatever reason the house doesn't make any sense anymore and they're going to walk away from it. That might be the person. I had a client not very long ago that relocated from out of state to Texas. Well, the economy in that particular little area was not experiencing this red-hot real estate market, and they couldn't unload that house. So at some point, we just determined that we would surrender that house. But the normal goal for everybody is to keep their house. So if what's caused you to file bankruptcy is not your ability to make your house payment, then we're probably looking at a Chapter 7 bankruptcy on the norm. If your problem is, I'm 6 months behind, I've got the letter, they're going to foreclose, then we're going to look at a Chapter 13, and we're going to be able to restart that mortgage. What happens is that let's just say we would file in September. Well, you would start making a payment in October to the trustee to pay your house payment. You don't have to catch up in one lump sum those 6 payments that the mortgage company is demanding plus their attorney's fees. So the goal is always to keep your house, and if your income is reasonable and steady, we can get that done almost in every case. Obviously, if the income isn't there, it's impossible to keep the house. But if you've just had a rough patch, we just need to get you restarted, we can help you save your house. And that's, of course, what most people want to do.
And, of course, that kind of, plays in right to the next question. We're talking about your house. What about your cars? What happens to that?
Well, once again, you want to keep the cars in most cases. If you are making those regular payments, we'll just continue to make those regular payments. But we see a lot of people who, in my estimation, come in too late. The car got repossessed last night or the night before. Well, if we act very, very quickly under our local rules, if we file a bankruptcy within 10 days of your car being repossessed, we can require the lender, the repossession people, to give the car back, and we get to start over again. So it's a big tool for us in bankruptcy regarding cars. So don't give up if you come out after work or in the morning and your car is gone. That's when you got to put it in gear and come see us, because we have a period of time that we can act very quickly. And our judges are very strong on making sure that the cars get returned to people, and we'll get that chance to start making those payments. So the cars are really a key issue that is a real unique area of the law. We can undo what's already happened if we file bankruptcy, compared to if your house gets foreclosed, I can't undo that foreclosure assuming it was done properly. But the cars allow us a really big stick as far as getting your car back and you getting to keep it. And, most of us without a car, we don't have a job, which means we don't have a house, it's just a spiral effect. So if you lose that car, rather than put your head down and give up, that's the time to run into the office and talk to us about what we can do quickly to get your car back and get your life straightened out.
Folks, we're talking with attorney David Pritchard of the Pritchard Law Firm. Of course, you can find them online at dlplegal.com. That's dlplegal.com. The phone number to reach out to the fine folks over there, it's 817-285-8017. That's 817-285-8017. We'll do one more before we take a quick break in regards to, and I'm when these situations happen, if they're having to file for bankruptcy or something to that degree, is the spouse involved? Does the spouse have to file as well, Mr. Pritchard?
Well, that's a really case-by-case question, but it's really interesting. It's one that people ask regularly. Let's say that you're in a family situation where you've been married 7, 8, 10, 20 years. We would expect in that case both spouses to file bankruptcy. There are advantages that in Texas we are granted certain property we get to keep. It's called exempt property. And when you file with your spouse, you get twice as much property that you can protect and keep. So that is one reason that it's oftentimes we add your spouse. The other would be that in long-term marriages, we generally find that both spouses are on the debt, and so we need to clean up both spouses. But we have those situations where the debt has been kept separate, or it's a second marriage and the debt's not all there. It's not required that your spouse join you, but sometimes we would see the advantage of it. Of course, we wouldn't want to file for you and leave your spouse liable for a bunch of debt, because as a family unit, that doesn't help you. One thing people always ask about is credit. And if your spouse does not file, it's still going to impact your credit. We want to make sure people understand that, so they're not making that decision, well, if my spouse doesn't join me, I can protect her credit. Because, of course, the credit companies are sophisticated enough to understand what's going on at your house. If you're filing bankruptcy, your wife's situation can't be in the best, even though she didn't need to file bankruptcy. But that's a case-by-case analysis, but it's a common question and one we can answer for you and help you guide what's best for you and your spouse.
It's Ask the Experts here on Talk Radio 1190, talking with attorney David Pritchard on today's show. Great to have him back on. We're going to take a quick break, real quick, and when we come back, we'll pick up where we left off. And, we're really discussing what all entails on your first meeting regarding your finances and building off that today on today's show. So really good topic of conversation. Stay tuned. This is Ask the Experts here on Talk Radio 1190.
At the Pritchard Law Firm, they are proud to offer knowledgeable first-class service to every single client. Backed by decades of experience in both collections and bankruptcy, our founder, David, represents creditors, lenders, and individuals who face a financial dilemma. At the Pritchard Law Firm, their caseload covers nearly all areas of the collection field, guarding clients' rights in regards to collateral and unpaid accounts. They regularly take on cases that involve home equity lawsuits, foreclosure, evictions, sequestrations, replevin, general collection matters, and bankruptcy matters under Chapters 7, 11, and 13 of the Bankruptcy Code. Most of our services are provided on a flat fee basis. This means you can set a budget for each file. We primarily represent clients in Fort Worth, Dallas, Parker, and Denton counties, as well as the surrounding regions of the DFW Metroplex. Contact the Pritchard Group today at 817-285-8017.
Welcome back to the show, folks. This is Ask the Experts here on Talk Radio 1190. We interview local prominent professionals here in the Dallas-Fort Worth area. This show's no different. We got attorney David Pritchard joining us on Ask the Experts today. Of course, real quick before we get back to him, we can throw out the number, 817-285-8017. It's 817-285-8017 if he'd love to hear from you, and if you just need to pick his brain a little bit, ask him a couple questions, totally fine. Of course, you can find him online at dlplegal.com. That's dlplegal.com. And we're going to pick up where we left off. We're talking about, what happens in a first meeting regarding finances and kind of building off that, because there's always a lot going on in his world. But we were talking about if the spouse had to file, and you answered that for us. What about work? If you have to file for bankruptcy and you're in this situation, does your work have to know about you filing for bankruptcy?
Well, first of all, we'll assume that you don't owe any money to your work.
Okay.
If you owe money to your employer through some sort of you work at some place that has a loan program, then of course we're going to have to disclose to them because they would be a creditor. The normal Chapter 7 case, your employer, since he's not owed the employer is not owed any money, would not receive any knowledge regarding your bankruptcy. It's your personal business, and we have moved well past where bankruptcies used to be published in the newspaper and all that. Now to get the information, you have to go to a website that you have to be a member of to be able to look that up. Chapter 13 is a little different. Chapter 13, because we need to make sure that you make your payments and move forward on time, the court's going to require a wage garnishment or an allotment to pay the court out of every paycheck you receive. Now, if you're an employee, that's going to be there. If you're a contract worker, well, then you don't have the traditional employer. You may get a check from them, but you would then pay that directly. So it just depends. Federal law says that they can't harm your job or terminate you or punish you in some way because you filed bankruptcy. And I've been doing it for a long time, and I have not seen an employer take action against an employee. So there's a possibility they'll find out about it, but not always.
I think that's pretty good news overall for most people. If they had to go that route and decide to file for bankruptcy, I think most people are curious, what is the first step? How did they start this initial process?
Okay. We're going to say they've come into the office and they've talked to us about the things that we're talking about today. And then what we're going to do, Matt, is we're going to give them a worksheet, and that worksheet's going to be over 50 pages. We are going to guide them through how to supply the information to the court so there are no problems. We're going to ask about things that most people don't have. We're going to ask about your real estate, your house. Do you have a rental property? Do you have an investment property? We're going to ask about everybody that you might be involved with and who you owe. So at the end, when you complete that worksheet, we have the ability to provide the court with a true and correct picture from you. Because you can imagine the worst thing that I think can happen is we go to court and somebody starts asking questions and as the client, you're forced to say, oh, I forgot to tell you I own a boat. Well, now everything you've said has been thrown in question because you forgot to tell about something that could be very important. It may be a little rowboat that costs $300 and nobody cares, but it may be a speedboat that you paid $40,000 for. So our goal is to give you information so that you can complete that packet and we can complete your information to the court. Now, I'll tell you that if your finances you've got records, then that's like a 60-minute project. If your finances are a wreck, well, you got to gather up that information before you can provide and work out that worksheet. And if you're just overwhelmed by it all, come into the office and somebody in my office will sit down and help you fill that worksheet out because it's that important that we get the first step done right.
In regards to timing, is there a certain timing consideration when you're filing a bankruptcy? I'm sure there's some type of limit on that or whatever that might entail.
Well, one of the most important tools we get when someone files bankruptcy is called the automatic stay. Matt, that means that the minute we file bankruptcy, none of your creditors can take any action against you.
Okay.
So obviously, if the creditor is taking some action that we're concerned about, we want to file the bankruptcy prior to that action taking place. The main one that we see is if your house is set for foreclosure. In Texas, we do foreclosures on the first Tuesday of each month. So you can guess that the first Monday in the weekend before is a busy time to file bankruptcy for lawyers because we want to stop the foreclosure of people's houses. I talked a little bit earlier about the cars. If your car gets repossessed, we got 10 days to get that car back. So timing is important there. Now, the beauty of bankruptcy normally is that as far as judgments, we can wipe out a judgment whether it's the lawsuit's just been started, whether trial's been started, whether the judgment's been taken. We can wipe that out. So timing is not that important regarding lawsuits, though we want to stop them before they begin collection activity. So timing is important when it is important for us to stop action. And most people are coming in the office because they're motivated by something, a lawsuit, a repossession, a notice of foreclosure. So we normally address timing of a case in all files.
After this case is filed, and we're talking with attorney David Pritchard of the Pritchard Law Firm, DLPlegal.com. That's DLPlegal.com is the website. You can find them at 817-285-8017. That's 817-285-8017. Once they file this, what happens next, sir?
Okay. As far as the client's concerned, the next thing that happens is what's called a meeting of creditors, or a Section 341 meeting. Section 341 of the Bankruptcy Code is the code section that provides for this meeting. Now, that meeting typically is scheduled for about 15 minutes. They're very short. If we've given the information that I've talked about where we want to give the precise information, it should go quickly and smoothly. Today, and it's been going on for a while, those meetings are either done by Zoom or they're done by telephone. So the clients don't have to come into the trustee's office or to the courthouse to do that. We're able to do them by telephone or Zoom. The other thing that's always interesting is people say, well, are all my creditors going to be there? Matt, in 90% of our cases, there are no creditors. It's your lawyer, yourself, and the trustee. Because the creditors don't want to, my term is, throw good money after bad.
Yeah.
They know that we've filed bankruptcy, we've pulled out our big club, and we're knocking them down, and so they're not there. Now, there's always the exception. If you owe money to somebody who's really angry at you, and it's a personal loan, they may show up, but all you have to do is tell the truth. And once again, it's a telephone or Zoom discussion, so they're not there getting in your face or bothering you after you leave the courthouse. So, but that's the first step, and by the code, that happens in approximately 30 days, and that happens in every case, and we need our clients to participate and answer questions under oath. But like I said, they're very simple. They're relating to the documents that we've already prepared, and if we answer appropriately, we just move on to the next step, which is the case just proceeds along.
We got a couple minutes on the show, Mr. Pritchard, so I kind of want to end it with this. When people reach out to you for your services and your expertise, of course, I'm sure one of the main questions is how do I pay you? How do they take care of you as a lawyer if they do seek out your services?
And, of course, that's an important question for both of us.
Yes, absolutely.
I want to get paid, and you want to be able to handle it.
Correct. So
we'll talk about the Chapter 7. Generally, we're able to show people how our service will save them money. We will be able to show you don't have to pay this debt, you don't have to pay this debt, you don't have to pay this debt, and our fee will be considerably less than the debt. So that debt that you've been having to put out and pay out month to month that's not going down, you can use that money to pay your attorney. My office will do payment plans. You can't use credit cards, obviously, because that's a credit transaction and we're filing bankruptcy. In the Chapter 13 case, there will be a small down payment, and then the balance of our fees are paid by the Chapter 13 trustee. Remember, earlier I referred to that you're going to get payments taken out of your paycheck. Well, if I can't put a successful plan together for you, I don't get paid the same as the creditors. So it's all about, in both cases, us being able to create a cash flow situation that improves your current situation and makes sense to file the bankruptcy, and included on that makes sense to pay the court-approved fees.
One more time, it's 817-285-8017. That's 817-285-8017. It's dlplegal.com. That's the website. You can find them at dlplegal.com. It's attorney David Pritchard of the Pritchard Law Firm. We covered a lot on today's show. We didn't get to everything, but Mr. Pritchard, it's always great to have you on Ask the Experts, bringing us a ton of information as always.
Thank you. Enjoy the time, and hope everybody has a great weekend and listens to the rest of your shows.
Absolutely. And folks, 817-285-8017. We didn't cover everything, but if you want to reach out to him, like I said, he would love to hear from you. Give him a call at any time at his law firm. One more show on today's Ask the Experts, so stay tuned for that. We'll be right back, folks.